I think we're at the end now. Let's have both sides approach the podium. I'll begin with the state. You can tell me what you're seeking and why. Can you pass up a score sheet too?
Yes. Your Honor, I have argument. It's going to take a lot longer than a few seconds.
Okay, you may proceed when you're
And
ready.
I would also like to pass up these photographs that I've already shown to the defense of Mr. Wright. They are not to be entered into the record, into evidence, just for the court to review, and I'd like to return them to Amy Thompson, Mr. Wright's mother.
Any objection to me reviewing these photos?
No, Your Honor.
Okay. Okay, I've reviewed them.
Thank you. Your Honor, as you pointed out, the jury unequivocally rejected the defendant's self-defense claim and found him guilty of manslaughter with a firearm. The jury found that the defendant did not fear imminent death or great bodily harm when he fatally shot Colton Wright. The jury declined to find that this killing was justifiable or excusable. Instead, the jury unanimously found that the defendant committed a deliberate, intentional act which caused the death of Colton Wright. In other words, manslaughter with a firearm.
Your Honor, excuse me, that's not the law for manslaughter. It doesn't require intentional. It's heat of passion.
All right, you'll each have an opportunity to be heard, okay? Please continue.
The defendant committed a deliberate, intentional act. I am not arguing that he intended to kill. I am quoting from the jury instructions.
I'm aware that
it's an intentional act. I just want to make it clear, Your Honor, for those that don't
Please
understand the
continue.
law.
Please continue.
Yes. A deliberate, intentional act that caused the death of Colton Wright. Physical evidence rebuts the defendant's version of the events that he presented, both in the stand your ground hearing and the version that appears in the defense sentencing memo. If the defendant was sitting on a bed and Colton Wright was leaning over him with a bottle while the defendant shot Colton, the bed would be covered with blood, with tissues, with Colton Wright's teeth, which were scattered around the room, not on the bed. It simply doesn't happen the way the defendant tells us. And yet, the defense is clinging to that argument and asks for a downward departure based on the fact that they claim that Colton Wright was the initiator and a willing participant. Let's not lose sight that Wakey voluntarily and of his own free will went to that hotel room that night. Nobody forced him to go. Nobody put a gun to his head and made him go to that hotel room. Yes, Colton called him, asked him to come over. He's a grown man, allegedly intelligent, educated, and yet he chose to go over there, knowing that there was a tense, unpleasant situation that had already played out at his home, the defendant's home, when Colton chose to absent himself from that home and check into the hotel with Nick Trail. Here we have a 29-year-old man, 30-year-old man apparently, just had a birthday. He was 25 years old at the time of this offense. He was college educated, graduated from NYU, lived in Manhattan, one of the most difficult cities to survive in and navigate around, one of the most sophisticated cities in the world. He had a profession as a financial analyst, a job that required both moral and financial integrity, a job that he was paid to do, to make intelligent decisions, logical decisions, give people advice about their money. He was very sophisticated, very educated, very worldly in comparison to Colton Wright. So what do we know? On the night of the killing, Colton rejected him. And it wasn't for the first time, because we had video evidence that showed him literally begging Colton Wright to forgive him for being such a liar. I think his words were, "It's easier to lie than tell the truth." And again, that same night, Colton rebuffed him in Sarasota and went to a hotel with Nick Trail. It was clearly a very unpleasant situation, yet Colton called Wakey and asked him to come over. And Wakey, with his New York, worldly, sophisticated college education, financial advisor, somebody that's a high achiever, his family talks about how bright he is, he chose to go over there. That was his decision, freely and voluntarily. He went over to that hotel. And he ramped that up by taking a gun with him. And he ramped it up further by smoking meth. And let's look at Dr. Russell's deposition. And I know that I did not say, did Brennan Wakey smoke meth? But this is what the conversation was, and it doesn't take a genius to figure out what we were talking about. Did he tell you that he was smoking meth? Okay, there's a he, and she says yes. Okay, so he admitted to smoking meth? Yes. She wasn't talking to Colton Wright during that evaluation. And who would have admitted to smoking meth except for him? Because Colton Wright was dead. There was no
She
admission.
explained to you.
I know what she explained, and I find her explanation.
Page 8 and 9, he admitted to using meth. I don't know why you're making this into more than what it is. I'm confused by your argument, frankly.
I'm sorry that you're confused. I am not confused by my argument, and if you wish to reject it, certainly that is.
I wish to
you made
reject
it.
your argument.
Thank you.
Okay.
But nevertheless, I think it's important for the record.
Okay, the record is clear.
Thank you. So he ramped it up by smoking meth and drinking tequila out of a bottle. Now he claims that the victim provoked the incident. There would be no incident if the defendant hadn't voluntarily driven over to that hotel. There would be no incident. And he's claiming that Colton Wright started this incident. Just because there was a pre-existing relationship between those two men does not mean that Colton Wright was a willing participant. It's difficult to see how Colton Wright was a willing participant to getting shot in his own face. And then let's talk about the downward departure as to the defendant lacking capacity to appreciate the criminal nature of his conduct. The court should evaluate this mitigator by examining the defendant's actions both during and after the offense. Where a defendant, like Brennan Wakey, engages in purposeful, calculated conduct that indicates his awareness of the crime that he committed, it certainly should cast doubt on this mitigator, don't you think? For example, attempting to conceal evidence, fleeing, not calling 911, disposing of the weapon. All that demonstrates that Brennan Wakey knew exactly what he did. And don't tell me that his acute stressor alleviated the minute he fired that gun. that acute stressor disappeared, and then all of a sudden he became his logical self again when he collected Colton Wright's laptop, his phone, threatened Nick Trail, get out of the room, ran down the back stairs with a gun in his waistband and drove off without calling the police. He certainly had the ability to appreciate the criminal nature of his conduct. And that alleged PTSD that we heard about today, that didn't surface until after the defendant killed Colton Wright. That's what Dr. Russell said. There was an acute stressor, and now he has PTSD. There were no tests for malingering, and the alleged self-reported condition that we hear today should be compared side by side with what Brennan Wakey did when he left that hotel room that night and what he did the following day until the police finally picked him up. Before we talk about the jury finding of guilty of tampering with evidence, and let's not forget that goes side by side with the manslaughter with a firearm, let's consider the defendant's purposeful actions that night after he shot and killed Colton Wright. He took the victim's phone, he took the laptop, he fled the crime scene in his car, he didn't tell the police, he took the weapon that he used to kill Colton Wright, and to this day, that weapon has not been found. The jury's finding of guilty on count 2, tampering with the evidence, emphatically negates the mitigating factor of the fact that he lacked the capacity to appreciate the criminal nature of his conduct. Knowing that a criminal trial, proceeding, or investigation was about to be instituted, the defendant destroyed, concealed, removed items with the purpose to impair their availability in the proceeding or investigation. That's what the jury found. That's the jury instruction. They said, yes, he is guilty. He deleted photos on Colton Wright's phone, and he washed the clothes worn during the killing. This court has a superior vantage point because you also provided over the stand your ground hearing and heard the defendant's testimony, which actually varied wildly from what was presented during the trial. You have a distinct advantage, Your Honor, in assessing the defendant's credibility. Although the defendant recounted many times at that hearing how he and the victim incessantly fought with each other, how the victim threw objects at him, about that knife incident in that hotel room in Tennessee, about the fact that the defendant was sitting in a car when Colton Wright tried to drive them into a light pole, he never once related during the stand your ground hearing, and you never once heard during the trial that there was an acute stress response to any of those incidents. And yet, now, today, he has no capacity to conduct his behavior to the dictates of the law. That is not a valid ground for departure, Your Honor. The defense also asks the court to consider that Mr. Wakey has to live his entire life, knowing that he caused the death of Colton Wright, somebody that he cared for. Well, the state's asking you to consider what he said to his stepsister at Grandma's funeral in Port Charlotte. I popped him in the face. I can't wait to write a book so that I'll be more famous than Kim Kardashian. That shows a callousness and a gloating indifference to another person's life. A person that he cared for? Hardly. Colton Wright died when he was 24 years old at the hands of the defendant. He was younger, less educated, less sophisticated. Certainly he was less financially solvent than Brennan Wakey. Yet the theme that runs through this entire case like a thread is that somehow Brennan Wakey was a victim of Colton Wright, that he was traumatized by Colton Wright, that he was acutely stressed by Colton Wright. The facts say otherwise. The state is asking for 30 years in the Department of Corrections for count 1 and 5 years in the Department of Corrections to run concurrent for count 2. Thank you.